Okay, so everyone, today we're going to finish out the lecture for civil rights and civil liberties. This is going to be my final chapter. This is chapter 7. And yesterday we left off with looking at what rights do defendants have according to the Bill of Rights. And we've kind of gone through them, right? And so we looked at the Fourth Amendment, which is the protection against unreasonable search and seizure, which largely gets at warrants, right? And how police officers or the government can actually um, search your premises, search your house, search you. Then we talked a little bit about the Fifth Amendment and how the Fifth Amendment, which we oftentimes hear in movies, is I plead the Fifth, right? Which protects people from the right of, has the right not to self incriminate. And we left off yesterday talking about the very pivotal and one of the must know cases, which is Miranda v. Arizona, which the finding by the court in Miranda v. Arizona gave rise to the famous Miranda rights. You have the right to remain silent. You have the right, you have the right to a lawyer, right? And so basically, this is where we're picking up here today. We said that from that point on, the courts have ruled that it is the government's obligation to inform citizens of their rights, even if they don't know them themselves. So you have to, as a government agent, tell somebody when you arrest them or about to search them that they have the right to remain silent. You have to inform them, not of their Miranda rights per se, but of their Fifth Amendment rights, right? And the right to self-incrimination has been interpreted by the courts to mean lots of different things. And so, in addition to the right not to say, I did it, I killed the man, or I stole the thing, or I, burned this house, you also have the right under the Fifth Amendment, protection against self-incrimination, to avoid being entrapped by the government. And some of you are aware of what the term entrapment means, but essentially what entrapment is the government can't offer you something illegal, and then when you take it, they arrest you, right? And so this gets a little tricky here because sometimes the FBI or the CIA will lay stings for terrorists in online chat message boards. And the line that the courts have largely found, what rights do defendants have according to the Bill of Rights, is that while the government can kind of to a degree lay a trap, they can't basically make it so the only way that you would have done something illegal was for the government to actually motivate and give you what you need. So, for example, in a chat room that frequented by maybe a terrorist recruiting site, you could have a CIA agent basically start to talk a little bit about, plots against the United States and the American people in American cities. And then, that would be fine. And then if somebody, messages that person and says, hey, I live in Detroit and I really want to blow up, um, a large subway building in Detroit, can you help me? And the government agent says, sure, I can help you, and kind of gives them some stuff and then gives them the bomb making material. The courts would largely say that's not exactly entrapment because that person solicited that help and said, hey, here's what I'm planning on doing. Can you help me? But if the government basically approaches someone on the street, let's say an Arab citizen, and says, hey, you look like somebody who has, who's Arab and angry, and so I want to give you bomb making stuff, to blow up American people, and the person says, okay, then the government can't arrest that person because that person's illegal actions would have been largely motivated by the government himself, and that is entrapment. Something that the Fifth Amendment, protection against self-incrimination, says is against the Constitution, right? The government can't actively entice people to commit crimes. And there is, again, a tension in a line here that courts have used multiple decisions in order to clarify what exactly constitutes enticing versus what is maybe basically taking people who already want to do illegal things and then kind of supporting them until you can get a conviction. Final slide here in today's is continuing on defendants' rights as we look at the Sixth Amendment. So if the fourth is protection against unreasonable search and seizure, and the fifth is the protection against self-incrimination, the Sixth Amendment makes pretty clear that if you are arrested of a crime, that you have the right to counsel, you have a right to a lawyer, you have the right to confront your witnesses, and you have the right to a speedy trial. All of that is basically saying that if somebody, right, like rats on you and basically says, hey, my neighbor is planning on doing illegal things, the cops can't arrest my neighbor and say, well, we can't tell you who told us, right? Because I could be lying and my neighbor would have the right to confront me in trial. And so all of this stuff, again, like you have seen in everything else, was originally stated in the Constitution, but it took Supreme Court cases and the decisions by the court to clarify exactly what the words of the Sixth Amendment mean. How far do they go, right? What are the limits? Where can they be used? And so, as we look at the Sixth Amendment and the pretty simple wording that you have the right to counsel, the right to confront witnesses, the right to a speedy and public trial, it's not exactly clear how that looks, and so let's look at some of the ways that it was incorporated. Well, the Sixth Amendment was first incorporated in Powell v. Arizona, where basically if a state arrested, so the Sixth Amendment made clear that you always had the right to counsel in a federal trial. But prior to incorporation cases, if the state of Alabama arrested you for something, it was unclear prior to case law being established whether in a state level case, whether that person can accused of a state level crime also had the right to counsel. And so Powell v. Alabama incorporated the right to counsel first at the state level, but specifically in capital cases. So if you were charged of murder or some other serious enough crime where the death penalty was a possibility, that the Sixth Amendment at every state would have required that you have the right to access to counsel. Now, just as a quick check for you, anyone want to take a guess as to what was the reasoning that the Supreme Court used in order to incorporate the Sixth Amendment at the state level? If you said the 14th Amendment in your mind, right, and the right to due process and the Equal Protection Clause created under the 14th Amendment, you would be right. The 14th Amendment was invoked in Powell v. Alabama that basically said that a person has the right to counsel if they are arrested of a serious enough crime where death is actually a consequence in every single state. And that just because somebody lives in the District of Columbia doesn't give them more rights than, say, Alabama. And so the 14th Amendment was invoked, just like it is in most incorporation cases, in order to take this federal civil liberty and apply it to the states. Maybe a more famous case, and the one that actually had a farther reach than Powell v. Alabama, would have been Gideon v. Wainwright, another one of your must-known cases. Gideon v. Wainwright took the reasoning established in Powell v. Alabama under the 14th Amendment and basically said, we're going to go a step further and say anytime a person is charged with a felony, meaning they have the real threat of serving jail time, then the Sixth Amendment applies to them, that they have the right to counsel. And so Gideon v. Wainwright, the decision by the Supreme Court in that case, incorporated the right to counsel at the state level in all 50 American states for any time somebody had been charged with a felony, that they can say, I would like a lawyer, right? And one would have to be provided to them, right? This has since Gideon v. Wainwright been extended not just to felonies, but any misdemeanor that is serious enough where jail time, where the actual deprivation of a person's freedom is a possible consequence. So there are misdemeanors out there where you could have to serve, a week in jail as a result of this misdemeanor. And if jail is a possible consequence, then the due process clause of the 14th Amendment would say, well, if we're going to take away your freedoms and put you in jail, then you have protection under the due process clause. You are fully protected by the law, right? And so they were used the 14th Amendment again to extend the rights of counsel, not just in Powell v. Alabama, which was capital cases, and Gideon v. Wainwright, which was felony cases, but then pushed it even further to say any case where jail time was a real possibility, you would have the right to counsel. The Sixth Amendment also has given you the right that you have the right to be informed of charges that, what are you being charged with, right? The police can't just show up, take you to jail, and when you say, what am I being charged with? They say, you should know, right? No, you have to tell me. We are charging you with, theft or burglary or anything else. You also have the right under the Sixth Amendment to confront witnesses and be able to like look at your witnesses in the eye and cross-examine them to basically see, right, is that witness telling the truth? Could they have another agenda? Could they be, biased against you and therefore are, exaggerating what they're saying, right? That the Sixth Amendment says you have the right to confront witnesses. And this again came from the abuses by King George, where American colonists were being tossed in jail and without the ability to even question their accuser, right? It was just basically their accuser said it, so they're guilty. And so the Sixth Amendment is providing all of these civil liberties, that defendants have the right to these things. That you have the right to trial, right? A public trial, meaning trials cannot be held in secret behind, community's eyes. That, if you wanted to, as a citizen of Colorado and El Paso County in the United States, you could go to the federal courthouse in Denver and sit in on any trial you wanted because trials are public, right? And if it was like a private trial or a secret trial, you can see how somebody's civil liberties could be taken away more easily, right? But the fact that all trials are readily available to be seen by anyone means that they have to be dealt with a certain way. The government can't cut corners. And again, that's the 14th Amendment and the due process, right? That you have the right to a trial, a public one. You can waive your right to trial if you want by, striking a plea bargain deal where you make a deal with the district attorney or the U.S. attorney or the attorney general to basically say, all right, I waive my right to trial in exchange for you not seeking the death penalty, or I waive my right to trial in exchange for, only serving 1 year in prison instead of 10. That the Sixth Amendment also guarantees you the right to a fair trial, and that if you want to, you can take a trial by jury. You can choose as a defendant to have a trial in front of a jury of your peers, where your lawyers get to kind of pick an impartial jury, or you can elect to just waive your right to a jury trial and just have the judge decide. The Sixth Amendment guarantees all of this, and that any evidence that could increase the penalty of your crime would have to be proven beyond a reasonable doubt by the government, right? Again, there's that kind of Fifth Amendment crossover where they can't just put the defendant on the witness stand, swear him in under a Bible and say, sir, now tell me the truth. Did you do it? This also ensures that judges can only sentence according to the jury verdict. So if you choose a jury trial and the jury says, well, we're going to sentence you to 1 year in prison, the judge can't then say, under the Sixth Amendment, right, the judge can't then say, I disagree, you deserve 5 years, right? If they choose a jury trial under an impartial jury of their peers, then whatever the jury says goes. Final point, defendants have the right to know about any evidence that could exonerate them. So if in the course of an investigation, right, prosecuting attorneys come upon evidence that finds that they believe could exonerate you or prove your innocence, and they say, well, shoot, we can't make sure this, we need to make sure that this evidence doesn't get to the defendant, because if they get this evidence, they're going to be found innocent. That is illegal, right? That police officers and prosecuting attorneys are required to share evidence with defense attorneys anytime they find evidence that could possibly be used to exonerate. And if it's found after the trial is over that didn't happen, that the prosecuting attorney or the police or whoever didn't share that evidence with the accused or their defense attorneys, then that would be a mistrial and you would go free. And quite frankly, there's quite a few appeals launched, every year, like hundreds, if not thousands of appeals by defendants who've been found guilty, who launch an appeal to an appellate court based on that argument, that they didn't know, they didn't have access to this evidence that they could have used to argue their innocence, and that the Sixth Amendment makes pretty clear that that also is a requirement. All right, everyone, that concludes my Civil Rights and Civil Liberties lecture series. Tomorrow, I'm going to move into kind of doing a cursory lecture review of all the must-know states. So at this point, hopefully you're done a lot of the research. You only have a couple cases left before Friday's quiz. I will start tomorrow by kind of doing a lecture through each one of them, briefly touching on the main storylines, giving you a little bit more to remember, and helping you hopefully understand how those decisions in case law came to be. All right. Have a good rest of your evening, everyone.